take these headphones off here. Let's watch it. Matter of fact, I'm even going to switch the camera around real quick. Let's watch it. I'm going to let this play for a second here real quick so you guys can just see what we're looking at. So they let themselves into the house. They have the key to the house. They have a warrant. I can't find out what the warrant's for. We're going to look that up, though. We're going to find out what the warrant's for. Less than 10 seconds. It's less than 10 seconds before they kick the couch. They see a gun. They shoot him. He's at home. And they shoot him within 10 seconds. And now you're going to see it live time right now in a second. You're going to see it. You're going to see it. Here it is. Executed. Executed. So now let's watch it again. So why do you need to go into someone's house? What's the point? The war on drugs is we've never had a bigger drug problem. He doesn't have kidnapped children in there. Why do you need to go into someone's house? Why do you have to go and raid someone's home? How come you have to go right there? What is so important? And I started to research today bloodhound dogs. And I found out that bloodhound dogs were originally bred to chase down human beings. And so we've had this mantra, this idea that what we need to do is hunt down people. And you're hunting them down for what? What are you hunting them down for? Why are you hunting these people down? What have they done so bad? Just like that. Just like that. I mean, you should let it burn into your mind. Watch. This could be your house they have the wrong key for. This could be you. This could be you right now. We have to bring to a total and complete end the idea that police can raid your house. Unless you have kidnapped children and you're saying you're going to kill them, police should no longer be able to raid our homes. This should come to a total and complete end. We, united, should say, we no longer accept you raiding our homes. We no longer accept this. Look how fast. Count the seconds. Ready? Do it with me. 1001, 1002, 1003, 1004, 1005, 1006, 1007, 1008. 8 seconds. He has 8 seconds in his own home to live. That's how long he has. What is so pressing? Why do you have to go into this man's house? Why? How come? I don't understand. Isn't it ironic his last name is Locke, Amir Locke, and our country's founded on the principle of natural law, and John Locke, and now we're seeing the same namesake be killed today in 2022, executed as he's asleep, guys. He's asleep. He's not even awake. He's waking up to guys kicking down his door and screaming. He's not even, listen, I need a cup of coffee before I can even wake up in the morning. I don't know how you are. I don't understand why this is acceptable. We as Americans need to say we no longer accept you raiding our homes. We no longer accept you raiding our homes. We don't accept it. The rule of recognition, we no longer accept it. No more raiding people's houses. The only way I want to see someone's house raided is if I know that they have children in there that they're molesting, and it's an orgy of children, and we want to stop the orgy of raping kids. Otherwise, you should not be able to go into someone's house. Remember, the Minneapolis Police Department, these guys right here, this is the same where the defund movement began, because the Minneapolis City Council said, we've been monitoring these guys for years and we can't get them to stop. So we're going to defund them. That's where the whole idea of defund actually came from. It's the Minneapolis City Council. where they said, we're gonna defund our police department because we can't get a hold of them. We can't get a handle on them. We can't get a handle on them. Just disgusting. Let's get into something here. Let's get into something. Okay, let me just get my, this is going to be Graham versus Connor. This is where the use of force policy comes from. This is from 1989. Let me get my speakers on here. Bose mini sound link.
This is submitted. We'll hear argument next to number 876571, D. Thorne Graham versus M.S. Connor. Sir, you may proceed whenever you're ready.
Mr. Chief Justice, and may it please the court. On November 12, 1984, Thorne Graham was not a convict or a criminal. He was not a pretrial detainee. Indeed, he was not even a formal arrestee. He was a free citizen of the United States of America who on that date had an insulin reaction. And he called upon a friend to take him to a convenience store where he could purchase some orange juice to help counteract the effect of the insulin reaction. Upon arriving there, he noted that because of a line, it would take him a long time to get his orange juice. And he became concerned and ran to his friend's car and motioned for him to take him to his girlfriend's house. A Charlotte, North Carolina police officer saw him hurriedly exit the convenience store and determined the conditions to be suspicious enough to allow for a brief investigative stop to determine the facts. Upon making this stop, Mr. Berry immediately informed Officer Connor that Mr. Graham was indeed suffering from what he described as a sugar reaction. At this time, Officer Connor asked Mr. Berry, or told Mr. Berry, that he must remain with Mr. Graham at that time while he determined what happened at the convenience store, and he began to depart. This time, the petitioner became concerned, and according to his testimony, he has little memory of what occurred, most likely because of the continuation of his insulin reaction. He exited the car and ran around it twice, and then sat down on the curb. From this point forward, taking the evidence in the light most favorable to the petitioner, as must be done on a directed verdict, he was seated at that time, again peacefully talking with the police officers when backup officers arrived. We know that those officers must have been told of the alleged sugar reaction before the first comment.
Doing when the officers arrived, you're sitting on the curb.
Sitting on the curb.
Was he conscious?
Yes, he was at that time.
Had he been?
Yes, he had been conscious, but he has no memory of those events.
To whom was he talking?
He was talking to Mr. Berry and to Officer Connor at that time when the backup officers arrived. And we can tell by the comment of the first arriving officer that they were explained about this sugar reaction, because the first comment was, I've seen a lot of people with sugar diabetes before, but none that ever act like this. He must be drunk. Let's lock him up. And they grabbed him. And they turned him over and they handcuffed him very tightly. So tightly that at the conclusion of this episode, he had cut wrists. And they lifted him up by his arms and they carried him to the hood of Mr. Berry's car and laid him over it. At this time, he regained his senses and began to talk with the officers and complain about the treatment he was receiving. And he asked them to please check his back pocket for his diabetic decal to show that he was indeed a diabetic. The response was an officer told him to shut up and slammed his head into the hood of the police car, Mr. Berry's car. A few moments later, no less than 4 police officers grabbed Mr. Graham, one on each arm, one on each leg, picked him physically off the ground, carried him to a police car, opened the back door, and threw him in, to use the petitioner's words, like he was a sack of potatoes. and they drove him home, never arrested him. And when he arrived home, they unhandcuffed him, and he fell flat on the ground. And he was carried within a few moments for medical attention, and an examining physician discovered he had a broken foot. He in fact had an insulin reaction. His blood sugar count was very low. And they discovered that he had cut wrists, and he had a large abrasion over his right eye. He had an injured right shoulder that prohibited him to the extent that for 2 weeks he could not administer his own insulin shots. He missed 5.5 weeks of work with the North Carolina Department of Transportation. He incurred medical expenses, all as a result of this. On these facts, the lower courts on directed verdict held that these acts by the police officers had violated no constitutional right of Mr. Graham to be free from bodily harm and physical abuse at the hands of law enforcement officers.
Okay, so this is the Graham versus Connor case. I think it's important that we talk about the Graham versus Connor case, and just so everybody who's coming in the room knows, I'm just going to real quick put Graham versus Connor across the top of this so that everybody can just see it, and it'll just say Graham versus Connor. This is on my Premiere Pro. I couldn't wait to show this because of watching Amir Locke get murdered, and they went into his house and they murdered him. It's just, they just murdered the guy. You guys just saw him get murdered. It's just so incredible to me. It's just so incredible. So I want to talk about the use of force policy with the police and how the use of force policy was created. And what you guys are going to be able to tell by watching this with me is you're going to be able to tell how much more important Terry versus Ohio is than qualified immunity, because now you know about qualified immunity if you watch that long video. Even though it wasn't that entertaining, it was still informative. I'm just finding the exact place we left on.
Barry and to Officer Connor at that time when the backup officers arrived.
God bless it. Good Lord.
And we can tell by the comment of the first arriving officer that they were explained about this sugar reaction, because the first comment was, I've seen a lot of people with sugar diabetes before, but none that ever act like this. He must be drunk. Let's lock him up. And they grabbed him. And they turned him over and they handcuffed him very tightly. So tightly that at the conclusion of this episode, he had cut wrists. And they lifted him up by his arms and they carried him to the hood of Mr. Berry's car and laid him over it. At this time, he regained his senses and began to talk with the officers and complain about the treatment he was receiving, and he asked them to please check his back pocket for his diabetic decal to show that he was indeed a diabetic. The response was an officer told him to shut up and slammed his head into the hood of a police car, Mr. Berry's car. A few moments later, no less than 4 police officers grabbed Mr. Graham, one on each arm, one on each leg, picked him physically off the ground, carried him to a police car, opened the back door, and threw him in, to use the petitioner's words, like he was a sack of potatoes. And they drove him home, never arrested him. And when he arrived home, they unhandcuffed him, and he fell flat on the ground. And he was carried within a few moments for medical attention, and an examining physician discovered he had a broken foot. He in fact had an insulin reaction. His blood sugar count was very low. And they discovered that he had cut wrists, and he had a large abrasion over his right eye. He had an injured right shoulder that prohibited him to the extent that for 2 weeks he could not administer his own insulin shots. He missed 5.5 weeks of work with the North Carolina Department of Transportation. He incurred medical expenses, all as a result of this. On these facts, the lower courts on directed verdict held that these acts by the police officers had violated no constitutional right of Mr. Graham to be free from bodily harm and physical abuse at the hands of law enforcement officers. May it please the court, this decision is wrong, and it is wrong for 4 reasons. Initially, it is wrong because it fails to understand that whenever force...
Now, what court decision are you talking about?
I'm talking about the district court decision and the Fourth Circuit Court of Appeals.
We're reviewing the Court of Appeals decision.
We are, sir. Obviously.
What did it hold?
The Fourth Circuit United States Court of Appeals, we contend, created a generic hybrid type of constitutional right with no specific provision as to what the constitutional anchor for the analysis is. They permitted the consideration of the subjective intent of the officers when it is our contention that 2 decades of Fourth Amendment jurisprudence of this court forbids such an analysis.
So you say they applied the wrong rule of law?
Yes, sir. They are wrong because they fail to understand that whenever force is used by officers to seize a citizen, the Fourth Amendment, by its very own terms, preventing or prohibiting unreasonable search and seizure, controls analysis. The decision is wrong because it fails to apply the principles that were laid down by this court in Tennessee versus Gardner, an objective standard of reasonableness test to analyze this situation. It was wrong because it suggests, contrary to 2 decades of Fourth Amendment jurisprudence, beginning in 1967 with this court's decision in the Sperber case, that at a minimum, the Fourth Circuit held that it was relevant to consider, not only was the officer's conduct unreasonable, but whether the officer inflicted pain on the citizen maliciously, sadistically, for the very purpose of causing harm. The Fourth Amendment forbids that. Tennessee versus Gardner and Terry versus Ohio tell us. And finally, the decision was wrong because the court below erred as a matter of law in resolving credibility issues, weighing testimony, determining credibility in the light not most favorable to the petitioner, and drawing unfavorable inferences in deciding and affirming its directed verdict. Initially, all parties...
The cases he's talking about right here, these cases here that he's listing right here, the Fourth Amendment forbids that. Tennessee versus Garner and Terry versus Ohio tell us so. Tennessee versus Garner is based on the Supreme Court ruling that cops can shoot you in the back as you run away if officer safety is in question because of Terry versus Ohio. He's quoting bad case law that Graham versus Connor is going to be worse. If you're going to go past these things, he's saying, allowing cops to shoot people in the name of officer safety and allowing people to grab you based on them being suspicious of you, how much worse is it going to go is what he's saying. This is the baseline of horrid. And he's going to say exactly that in just a second here. Sorry.
And finally, the decision was wrong because the court below erred as a matter of law in resolving credibility issues, weighing testimony, determining credibility in the light not most favorable to the petitioner, and drawing unfavorable inferences in deciding and affirming its directed verdict. Initially, all parties in briefs concede that the petitioner was seized in this case when Officer Connor informed the petitioner and Barry that they were not free to leave. However, the inquiry does not stop there, for we are told in Terry versus Ohio that a seizure which is reasonable at its inception may violate the Fourth Amendment by virtue of its intolerable intensity and scope. Seizure which is reasonable at its inception may violate the Fourth Amendment by virtue of its intolerable intensity and scope. To quote this court in Tennessee versus Gardner, reasonableness depends not only when a seizure is made, but also how it is carried out. Tennessee versus Gardner relied upon 2 decades of Fourth Amendment jurisprudence of this court and analyzed an officer's use of force in seizing a suspect from an objective standard of reasonableness. May it please the court, Tennessee versus Gardner logically controls the disposition of this claim, just as Terry and its prodigy controls the framework of Tennessee versus Gardner. Inexplicably, the Fourth Circuit Court of Appeal fails to even cite or mention Tennessee versus Gardner or the objective standard of reasonableness, and instead embarks upon a determination of the petitioner's claim based upon a substantive due process concept, which was first formulated by the Second Circuit in its 1973 decision in Johnson versus Glick. In Glick, relying upon this court's 1952 decision in Roshan versus California, the Second Circuit Court of Appeals held that the Due Process Clause protects criminal suspects from police conduct that shocks the conscience.
Roshan versus California is when the cops shoved their finger down the suspect's throat and made him vomit. And so that was what shocks the consciousness of what use of force policy is based upon, if it shocks the consciousness. That's the whole point of Roshan versus California. I think it was 1953.
But of course, Roshan, the analytical predecessor of Glick, predated Mapp versus Ohio. And at the time Roshan was decided, the Fourth Amendment was not a part of the Constitution made applicable to the states. Nonetheless, Judge Friendly announced 4 tests to be used in analyzing the shock the conscience test, the fourth of which was a wholly subjective factor of whether the force was applied in a good faith effort to maintain or restore discipline or maliciously and sadistically for the very purpose of causing harm. These factors have since been used by a number of circuits, including the one below, to analyze excessive force claims. However, we submit that the continued use of this substantive Glick test, and particularly its fourth factor in seizure and arrest cases, is patently at odds with the express words of the Fourth Amendment and the holdings of this court. And that is for 4 reasons.
Mr. Beaver, don't you understand that your opponents here concede that the Fourth Amendment is the correct mode of analysis for these facts?
Okay, so Rehnquist is going to vote in favor of use of force being up to the reasonable officer on the scene. He's going to vote against this lawyer, Gerald Beaver, and he's kind of scolding him and saying, don't you understand that we know the Fourth Amendment is the standard of freedom in America? And then he's going to vote that cops can use any amount of force that they deem reasonable in their minds.
I understand that they do so in their briefs, sir. Yes, sir. I do that. But what they do not concede is that they would have this court believe, and the Fourth Circuit would hold, that its decision, which relied upon the 4 Glick factors and discussed the 4 Glick factors, it would have us believe that that's simply another way of stating objective standard of reasonableness, and it is not. Objective standard of reasonableness strictly forbids the look at subjective intent.
Subjective intent.
Perfect examples, and the reason for this is it is irrelevant. It is irrelevant to an objective Fourth Amendment consideration. 2 examples. Tennessee versus Garner is a prime example of why it is irrelevant. In that case, clearly a majority of this court held that the conduct engaged upon by the officers was objectively unreasonable. However, the courts below, when it was never raised, the officer there clearly acted with a benign intent. He was not in any way malicious or sadistic or acting for the purpose of causing.
Oh my God. Oh my God. In Tennessee versus Garner, Eugene Garner, a 14-year-old kid, was in his neighbor's house and the cop shot him in the back of the head as he hopped a fence 30 yards away. The cop's testimony was that he was pretty sure the kid wasn't armed. And when he shot him in the back of the head, his gun was packed with hollow tip bullets. You understand that? His gun was packed with hollow tip bullets. And this lawyer is kissing their butts and saying, oh, he didn't mean anything bad by it.
Does the subjective factor have any bearing on any immunity that the officers might have?
It does not under this court's decision in Harlow versus Fitzgerald, where this court has driven subjective considerations from every aspect of Fourth Amendment analysis.
So under your view, I take it the immunity analysis collapses into the objective analysis under the Fourth Amendment, and the issue is simply the same?
Oh no, they're not. They're simply not the same. Tennessee versus Garner is a prime example of why it's not the same. Tennessee versus Gardner, the conduct was held clearly to be objectively unreasonable, At the same time, it was held to be within qualified good faith immunity
There was reliance because of reliance on a statute.
because of reliance upon the bright line test
In this
set forth
case,
by that.
in this case, are the two inquiries precisely the same?
I would think not, but with all due respect, there was no raising of the qualified good faith immunity defense in this case. It was never presented either by pleadings or in argument before the district court or before the appellate court. It was never raised. It's simply not an issue in the matter. Hypothetically, I can see no reason why this case would be any different with Tennessee versus Gardner. I think it clearly violates, can be argued clearly that it violates bright line standards to take a handcuffed man who merely asks you to look into his diabetic decal, grab him on the back of the head, and slam his head into a police, to a hood of a car.
Counsel, under the objective approach or test that you propose, I assume that statements made by the officers during the course of the arrest that might indicate personal animus would be irrelevant.
Okay. She's telling the lawyer that even though the cops were saying F and enter, look at the dumb enter, look at that crazy enter running around his car, look at that dumb enter. The cops are calling DeThorne Graham a dumb enter over and over and over again. And what she's saying here is the cops who are torturing this man, slamming his head into the hood, breaking his foot, popping his ribs, she's saying that, oh, what the cops said when all this was going on, it's not relevant, is it? She's the biggest cop sucker there is on this particular panel.
Yes, and may I explain? Or may I take one little caveat to that? I recall your footnote 13, I believe it was in United States versus Scott.
You guys, do me a favor, hit the like button. Just do me a favor, throw the number 1 up here. To put the number 1 up here, or the W for the win right here. Everybody just pot it in here, number 1 or W if you would, please, for the number 1 or win, and hit your like button real fast. Let's get more people in the room, because a lot of people should understand this is the use of force policy that's used against us today, and you're about to hear how they rip us all off.
In which you were talking about, this is the case involving the wiretaps, in which you indicated that perhaps such bad faith statements could be usable by the court in the criminal context, for example, to determine whether the exclusionary rule should apply. It can also be used in the civil context to look into credibility issues for a jury determination. If the officer is acting objectively malicious by his statements, clearly a jury can consider that in determining the credibility of him taking the stand and saying that things occurred in a different way. And finally, in the civil context, it's also useful for punitive damages questions.
Or that the officer's statements would have no relevance.
Other than perhaps in a decision by the jury whether to award punitive damages.
Some of the circuits have applied a pretextual seizure doctrine. For instance, a traffic arrest is made and it may be unreasonable even though the officer had probable cause, if in fact the officer was trying to make a drug arrest, for example.
She's actually predicting history right here. This is 1989. In 1996, the Supreme Court is going to create pretextual stops for police so they can stop you pretextually. This lawyer, it's foreign to him hearing the idea of a pretextual stop.
There are cases involving pretextual seizures.
I see.
You think your objective standard would preclude that kind of an analysis?
I believe that a pretextual stop is not objectively reasonable, if that makes sense. To arrest someone and seize them on a pretext, I think from an objective point of view can be argued is objectively
But you wouldn't
unreasonable.
look at the officer's true intent under your theory.
Let me back up and say, strictly speaking, with the objective test, I would agree with the Justice that it would be.
You can't hypothesize any case in which a seizure is objectively unreasonable and there is good faith?
Oh, I'm certain that there are many cases where there is an objectively unreasonable
Only with a statute?
seizure. Tennessee versus Garner is a prime example. There was good faith and there was
There's a
objective
statute.
unreasonableness.
There's a statute there.
put on the spot. It's very difficult for me to think.
Oh, come on.
I would certainly think that there are a number of situations cited in our briefs, and both ours and the Solicitor General as amicus, and I do not recall them specifically in my mind at this time, and I apologize.
Are you two whispering over there? Or what?
Okay, let me help you out, brother. Carroll versus the United States, Brinegar versus the United States, Kerr versus California, Terry versus Ohio. All of those contain objectively unreasonable stops that you could try to say were done in good faith, but they weren't. Let me help you, counselor. He hung his entire hat on the case being hinged on Tennessee versus Garner, and when they didn't buy his Tennessee versus Garner argument, that's all he has. And in a minute, he's going to show what lawyers are, because he has no passion, no love, no fire for the Constitution, and you'll hear it right here.
What's going on? I can't hear what you're saying.
He can't even think of
Pardon
the
me.
case.
I cannot think of one at this time. There are numerous hypotheticals set forth in both our brief and the brief of the Solicitor General as amicus. And, if I may, I would defer to those briefs. I apologize for not being able to come up with one at this moment.
Mr. Beaver, you have to run that one by me again, where you said that you cannot conceive of how a pretextual stop is always objectively unreasonable. I think we're playing with words there.
Well, I believe that I stated that.
You don't know it's
beginning of
objectively
my-
unreasonable
at the
unless you
begin-
know what the subjective intent of the officers is, right?
That's correct, and I have since rescinded that in speaking with the judges.
well, I
And stated that I do not believe that would be a situation. I think a pretextual stop would not necessarily be objectionably unreasonable.
Would not necessarily, it would not at all be.
It would not be objectively unreasonable.
So you'd be willing to apply your rule consistently so you can make as many pretextual stops as you want
Right.
without violating the Fourth Amendment.
May I state, sir, that this is not my rule. This is the rule from Tennessee versus Garner and from 20 years of
He hung his hat on.
objective
Whatever.
jurisprudence.
Whatever. You would still apply it consistently, though, and you think that pretextual
For
stops
purposes
are
of this
okay.
argument, I believe that I would, yes, sir. I do
But the
not.
next argument, you wouldn't.
Well, I might not. Depends on who my client is, Your Honor.
You just lost the case. You just lost the case. I just want to go back for a second, you guys. I want you to understand the importance of what they're saying here. That you could just pretextually stop anybody you wanted to, and it would not be objectively unreasonable. You have to understand what's being said right here. It's really important, because in 1996, they're going to make it legal for pretextual stops. So now that you know that piece of information, that they're batting the ball around right here in 1989. But then in 96, they're going to create pretextual stop rules in Wren versus United States.
Not be objectively unreasonable.
It would not.
So you'd be willing to apply your rule consistently so you can make as many pretextual stops as you want
Right.
without violating the Fourth Amendment.
May I state, sir, that this is not my rule. This is the rule from Tennessee versus Garner and from 20 years of objective
Whatever.
jurisprudence.
Whatever. You would still apply it consistently, though, and you think that pretextual
For
stops
purposes
are
of this
okay.
argument, I believe that I would, yes, sir. I do
But the
not.
next argument, you wouldn't.
Well, I might not. Depends on who my client is, Your Honor.
Loser. He loses the case. Because you're a wishy-washy lawyer who doesn't care.
Assuming then that the Fourth Amendment applies, the court below erred in considering either as an element of the petitioner's claim or as a conceptual factor, however that is defined by the Fourth Circuit Court of Appeals, the subjective intent of the officers. First of all, Section 1983, this court has on numerous occasions held, contains no state of mind requirement, and one must focus on the specific constitutional amendment itself.
Exactly.
As this court has held in Tennessee versus Garner and in Terry versus Ohio and other earlier cases, the Fourth Amendment calls for this objective standard. The Fourth Amendment does not prohibit malicious and sadistic seizures or seizures that are accompanied by severe injury. It prohibits unreasonable searches and seizures. And as I stated, I believe firmly that the subjective intent of the officers in making a seizure is wholly irrelevant factor.
The officer at least have to intend to seize the person?
Oh, yes, under this sounds as if Your Honor is asking whether there must be an intentional act to predicate this test, and we certainly are willing to concede that this case does not imply anything about unintended acts creating unintended injuries. This case is no more involved with that type of situation than Tennessee versus Garner was. I believe that what the Fourth Circuit opinion does, we mentioned a moment ago, or I mentioned the hybrid test, which is not specifically set to any particular constitutional amendment. Yet if you tell a jury that, in instructing the jury that they should consider the subjective intent of an officer, you're going to end up with many jury verdicts in which the jury says, well, the person was not being malicious or sadistic, therefore we should not find against him.
Now that's what a pretextual stop is, subjective intent. The officer looks at your car and believes that you could be part of a gang or you could be transporting drugs. So exactly what what jurisprudence lays out is that subjective intent is irrelevant. In 1996, in Wren, WHREN versus United States, they're going to allow the officers to use subjective intent to just stop anybody they want blindly.
As mentioned earlier, this court has driven subjective considerations, even from the good faith defense, goes even further. In the last term in Michigan versus Chesternut, this court drove any subjective intent requirements out of the decision as to whether or not a person felt that he was seized. The court held in Michigan versus Chesternut that a person is seized when an objective person, when a reasonable person under the circumstances would not feel that he was gone.
What if we agree with you that the Court of Appeals used the wrong standard? What should we do? I know you want us to reverse, but
We would argue the case should be reversed and sent back for a new trial, or at
For
a
a new
minimum,
trial?
yes, or at a minimum, new findings under the correct standard.
you mean in the Court of Appeals? They ought to review what the district court did under the right standard, or do you want us to?
May it please the court, the decision on directed verdict is a question of law.
Right.
The district court, the Court of Appeals, for that matter, this court has no discretion in how to determine the facts here. The facts are to be determined in the light most favorable, and this court, as well as is in as good a position as any court to read the bare record and determine what is the light most reasonable, or most
But
favorable.
if they reviewed the directed verdict judgment under the wrong standard, why shouldn't we just send it back to the Court of Appeals and say you should apply the right standard?
That is one option for this court. We, however, believe that this court is in as good a position to make that decision, and that clearly there is evidence in the light most favorable.
Then we have to study the record and know all the facts.
I presume
A lot of work.
Justice has studied the record and is familiar with the facts.
Should the jury be instructed that if the facts are as you state them to be, they must bring in a verdict for the plaintiff? What does the jury decide reasonableness in every case?
No, not in every case. Personally, I've tried two cases in which a court has told the jury if they find it in the way that the plaintiff has intended things occurred, they would find for the plaintiff. If they found it in the way the defense said, there are some cases which are clear. There are other cases which it is a jury question, when they have to resolve conflicts.
In this case, if the evidence is as you have explained it, and I recognize only one side's testified, then as a matter of law, is it an unreasonable seizure?
Yes.
In my opinion, in this case, were there no other side to be heard, yes, under an objective reasonableness test. You don't even treat arrestees like this. This is a Terry stop that got out of control as a matter of law without hearing from the other side.
Oh, shut up.
But there is another side to be heard. We're not asking this court to direct the verdict in our favor.
I understand.
Clearly, they have the opportunity to present their evidence and to make their arguments. The problem with this case is that the Fourth Circuit opinion, and I repeat, at least allows, if not requires, the consideration of subjective intent. The Fourth Amendment forbids it. Thank you.
So do you understand when he's saying the Fourth Amendment forbids subjective intent? What he's saying is that the Fourth Amendment is clear, that you're to be free of unreasonable searches and seizures. You see, he's saying that the Fourth Amendment makes it crystal clear that, that's exactly The law of the land is that paragraph right there. You have a right to be secure in your person, houses, papers, and effects against unreasonable searches and seizures shall not be violated. That's what he's saying. And this lawyer, you hear him, well, without the other side being heard, and, depends on who my client is. No, sir. No, sir. You lack the conviction and the heart and the courage to have taken this case. But now I won't get too lost in the second part because this is going to make you sick to your stomach as they argue for the fact that you should be able to grab people off the street and beat them down. And it's perfectly fine.
Thank you, Mr. Beaver. Mr. Levy, we'll hear now from you.
Thank you, Mr. Chief Justice, and may it please the court. We think petitioner has misunderstood the Court of Appeals decision in this case. That decision does not implicate the question the petitioner has asked this court to decide. The question presented and briefed and argued today by petitioner is whether excessive force claims under the Fourth Amendment in Section 1983 are governed by a subjective test. Now let me note that petitioner himself concedes in his brief that he never focused his claim on the Fourth Amendment either in the district court or in the Court of Appeals. Indeed, his complaint nowhere refers to the Fourth Amendment, even though it was filed approximately 4 months after Garner was decided. And today, petitioner faults the Court of Appeals for not referring to either Terry or Garner in its opinion, but I note that his brief in the Court of Appeals cited neither of those cases.
Yes, but the dissenting opinion did. Judge Butzner cited.
That's correct, it did. But this case was never focused.
Exactly a mystery, those cases at that time.
Excuse me?
Those are new cases. I would think the Court of Appeals normally would address itself when the dissenting judge decides them.
It certainly could have. But we don't think this case presents the question the petitioner seeks to raise in this court. For the decisions and the judgments below do not depend upon the application of a subjective test. And I say that for 2 reasons. First, the phrase maliciously and sadistically does not, as petitioner believes, refer to the actual subjective intent of the officers. Indeed, at the trial here, no one ever suggested that subjective intent was known.
Let me interrupt you for just a minute. Do you agree that this case should be decided under Fourth Amendment principles?
We agree that it can be analyzed under the Fourth Amendment.
It should be?
Yes, we would agree with that. I think there are some cases I should add, and this one may be debatable, that could be decided under the Fifth Amendment standard. The test proposed by petitioner is that the Fourth Amendment seizure continues so long as the arrestee is in the company of the arresting officers, which could continue after bail has been sent and the person bound over in the local jail. So we think that test goes very far. But on these facts, as we've got them today, we don't object to the application of a...
Okay, let's watch it. Let's see what it looks like. Let's take a good look at it. Let's see exactly what it looks like. Your channel. I'll show you the exact reenactment of Thorne Graham where he is arrested. I actually produced the entire thing out in the TV show, and I'm going to show you the actual scene of where it happened. Here it is. Oh, something happened. Oh, God. I guess it's not going to work through here. That totally sucks. So I'll continue to listen to this guy. I guess my volume won't work on my Bose player right through there.
Chille's Mac Mini, disconnected. Connected to Chille coded 70 and Chille's Mac Mini. Chille coded 70, disconnected.
We've got them today. We don't object to the...
I think I got it back, guys. No, yeah. the actual reenactment of
Hey there! Saw you run into that convenience store and run right back out again. What are you up to, boy?
Life's too long. I'm diabetic. I need sugar. It's sick. Why you report me? Why?
Suspicion, boy, suspicion. Terry vs. Ohio gives us the right to investigate anyone we're suspicious of. And that's you.
Please, sir, please. I need sugar. I could die. I need sugar. I could die.
You'll live. You know how I know? This is a store case from 1989. Graham v. Connor. The Supreme Court rules in favor of objective reasonableness, where cops can use force in this case and all cases. Force must be judged from the perspective of a reasonable officer on the scene, and that's me. I'm that officer. Stay down! He seems pretty fucking reasonable, doesn't he? You got something to say, boy? That's right, face down.
You know what sucks as a conservative Republican? Learning that all the cases, the Supreme Court cases, that took away our constitutional rights, the case was lost by a black man.
The Supreme Court has never helped me.
If you don't know the history, then you don't know that the Supreme Court in this country has been racist.
What can be done right now, right this second, to change things?
Overturn Terry v. Ohio.
No more these. Third-party agency for all the body cam footage?
In handcuffs altogether. Handcuffs are slave cuffs.
Tasers kill people. Ban tasers.
There needs to be a federal online complaint for all cop shops.
And a mandatory minimum punishment for all cops who violate our rights.
Overturn Florida versus Harris.
Overturn Wren versus United States.
In the caging system.
And the war on drugs.
You know, I want a 1-minute video on each of these. I'll pay for it. Put it on the website. Let's get a Netflix deal.
Yeah! So that's Jeff Lloyd. If you guys ever heard me audit before and say, if I go to jail, call Jeff Lloyd, that's actually the Jeff Lloyd. So now what I want to do is I want to show you guys something. I want to show you the case text. I'm going to go to the Justia and I'm going to go to the actual holding of Graham versus Connor. So you guys heard the oral arguments. They said, look, he beat him up. That goes against your Fourth Amendment right to be secure in your person, houses, papers, and effects. So this is on justia.org. And you could just scroll down, and when you go to Justia, we already know the story, so I'm not going to read you guys the story, but I'm just going to go down to the actual holding where it's right here. So here's the actual holding. Held. See where it says held right here? This is where the interpretation of Graham versus Connor exists. All claims that law enforcement officials have used excessive force, deadly or not, in the course of an arrest, investigatory stop, or seizure of a free citizen are properly analyzed under the Fourth Amendment's objective reasonableness standard. Objective reasonableness. Rather than under a substantive due process standard. Substantive due process is a substantive law, meaning that the humanity of the law is as important as the law. Whereas common law is based on judicial process. So A, the notion that all excessive force claims brought under 1983 are governed by a single generic standard is rejected. Instead, courts must identify the specific constitutional right allegedly infringed by the challenged application of force and then judge the claim by reference to the specific constitutional standard to which governs that right. So now if you want to file a 1983, which is your civil rights violation that's going to come from the 1966 Civil Rights Act, then each claim is going to have to be judged. You're going to have to specifically say which of your rights was violated. Claims that law enforcement officials have used excessive force in the course of an arrest, investigatory stop, or other seizure of a free citizen are mostly proper properly characterized as invoking the protections of the Fourth Amendment, which guarantees citizens the right to be secure in their person against unreasonable seizures, must be judged by the reference of the Fourth Amendment. The Johnson versus Glick test applied to the courts below is incompatible with the Fourth Amendment analysis that suggests the test's malicious and sadistic inquiry is merely another way of describing conduct that is objectively unreasonable. Do you follow? Let me go to Rehnquist's decision. See where you have right here? You just highlight this right here and you copy Rehnquist, put it up here, put it in your search bar, paste it. Rehnquist decision, Graham versus Connor. And now you're going to understand the exact what exactly what he said. It's absolutely disgusting. It's absolutely disgusting. So this is Oyez. I always talk about Oyez because when you get into it, it'll do some pretty cool stuff for you. It'll answer some questions for you that you probably couldn't answer on your own. Or at least you can't think about it, because remember, there's always a constitutional question. So there's the facts of the case. We already know what happened. So here's the question, the constitutional question of Graham versus Connor. Must Graham show the police acted maliciously and sadistically for the very purpose of causing harm to establish his claim that Charlotte police used excessive force? So there's the first constitutional question. Does Graham have to show that police acted maliciously and sadistically? That's the constitutional question for your Fourth Amendment under objective reasonableness. Must Graham claim that law enforcement officials used excessive force to be examined under the Fourth Amendment objective reasonable standards? So there's your constitutional questions. And then it was unanimous. They all voted on the side of the police officer that Graham's rights had not been violated by them breaking his foot, cracking his ribs, and okay, all the damages that happened to him. So remember the two questions? Must Graham show that police acted maliciously and sadistically? Does he have to show that? And then must Graham's claims be found under the Fourth Amendment objective reasonable standard? No and yes. In a unanimous decision ruling written by Justice Rehnquist, the court held that the claims of excessive force used by government officials are properly analyzed under the Fourth Amendment objective reasonableness. The court vacated direct verdict and remanded the case to district court to be decided by that standard. Rehnquist noted that in 1983, a civil rights violation is not itself a source of substantive rights, but rather a means for vindicating federal rights conferred elsewhere. Rather, the Fourth Amendment stands as one of the two primary sources of protection against physically abusive government conduct, along with the Eighth Amendment. Therefore, the validity of Graham's claim must be judged by reference to the specific rights conferred by the Fourth Amendment, not by a generalized excessive force standard. What they're saying is what the Fourth Amendment says is based on reasonableness. They don't want to have a generalized excessive force standard like getting your foot broken and your head cracked open. We can't just consider that a general principle. Judge Rehnquist, who is historically one of the worst Supreme Court justices of all time, rejected Connor's argument that malicious and sadistic is merely another way of describing conduct that is objectively unreasonable, and that the subjective motivation of the officers are relevant under the Eighth Amendment, not the Fourth. So they're saying that it should have been filed under the Eighth Amendment, not the Fourth Amendment. Remember what they said in the oral argument? So you're filing this under the Fourth Amendment? And he says, yes, don't you think so? And they're saying, no, it should have been under the Eighth Amendment. So they filed it wrong, essentially, is what Rehnquist is saying. Rather, he explained that the objective reasonableness is a use of force should be judged by the perspective of the officer on the scene. You see this? Objective reasonableness means that use of force shall be judged by the reasonable officer on the scene. So the cop on the scene who has the cuffs on you, that's the one who's going to determine the appropriate amount of force to be used on you. And that's written by a judge, by Judge Rehnquist. Do you think he ever was subjected to the kind of torture that we are? No, not a chance. Not a chance. And so then Blackmun, Brennan, Thurgood Marshall concurred. Thurgood Marshall was the black liberal Supreme Court justice. He concurred. Do you see? There it is. There I am again, back with do you see? Do you see? So, I think that, let's just go back one more time and let's revisit Amir real quick. Let's revisit Amir, and let's watch Amir, and let it burn into your head that you can be in your house. You can be in your house, and if for some reason there's a warrant for your arrest, if for some reason you're wanted, who knows why? The neighbor could have said that he saw you with a gun. For any reason, I can call the cops on you right now. You watching this, I can call the cops on you. You guys can call the cops on me and say, I know that guy has got a gun, and what happened to Amir could happen to you. Right this second. All you have to do is just call the police on someone and say, that guy is a danger. He's dangerous to me, dangerous to my family. He threatened to shoot me. He threatened to kill me. He said he had a gun. He said he had a gun. That's all you have to do. And if that's all you have to do, then what happens next is an absolute execution. It's just disgusting. So let's watch it again and let it burn. And this is Fairfax Police I'm sorry about that. I'm on the wrong video here. Let me just get to the history here. So there it is. Okay, you guys ready? So you're gonna watch this guy die. I'm so sorry. The entire thing takes less than 10 seconds. Less than 10 seconds. Ready? Here we go. They take a key, they go into his house for what? Because he's such an evil person. He's so evil they have to break into his house. Search warrant. Search warrant. Use of force will be judged. Use of force will be judged by the objectively reasonable officer on the scene. The reasonable officer on the scene will determine the appropriate amount of force to use on you. You're in your house, you got a gun in your own house. Real time, ready? 1, 2, 3, 4, 5, 6, 7, 8. 8 seconds. You got 8 seconds from the time they come in the door. If you have a firearm in your own home, they will kill you. So remember what we just learned in Graham versus Connor. We just learned in Graham versus Connor. The judge wrote that whatever the police think is objectively reasonable is reasonable. This is totally reasonable. This is what they're doing right here to this guy is totally reasonable. This is allowing the police to be an autonomous organization. This is what they consider reasonable. This is what the police consider reasonable right here. You're looking at it. This is your Graham versus Connor and Terry versus Ohio equals death. You guys do me a favor, hit the like button, hit the number 1 button, hit the like button, hit the number 1 button, please. Everybody hit that like button real fast. Hit the number 1 button because I know you guys get locked into watching stuff. Just hit that like button, hit the number 1. There it was. Let's watch it again. Let's watch it again. His name was Amir Locke. That was his name. His name was Amir Locke. His crime was he was asleep in his house, and they decided that he was wanted so badly that they had to break into his house. Search warrant. How well is this working out for us? Real time.
Police search warrant! Police search warrant! Police search warrant!
Once more, let's watch Amir one more time. Let's watch him again. This man's gone. Let's spend a minute for him. Each one's a minute. Let's watch Amir. This is Amir's last break.
Please search for it! Please search for it! Please search for it! Hands! Get on the ground! Get on the fucking ground!
So now I don't know if that's worse or better. You guys tell me. So a lot of people send me videos in. So I want to show you guys something that I saw that someone sent me in, and I want to expose this a little bit. Maybe we can, I don't know, go to this guy's channel and we can take a look. You know, I watched the Brookside Town Hall meeting. If you guys haven't seen that, it's pretty bad. But let me get into this video of what happens when the police just decide they're going to come over to your house and they're going to raid your house. Wait till you guys see this. You're gonna. This is the worst. I mean, it's just. So okay. So right here, you guys. This guy's channel is Morgan Hill SPB. You guys see that? Morgan Hill SPB. Sorry about that. Morgan Hill SPB. That's the number. He's got 6 subscribers. Let me zoom in real fast. So this is this guy's video, and I wanna show you what happened to this person. This is absolutely atrocious. So let me tell you what he says right here first, so that you guys know what happened here. Let's watch it, and then I'll come back because you guys are gonna want to know the aftermath. So without further ado.
Morgan Hill Police Department. Probation search.
Yeah, what's up? No, it's up and on. I bet you someone's living in there. Probably a dwelling in the garage.
Department probation search. Movement.
So this person's on probation, I think. We're gonna read the description in a second. I don't want to misspeak, but watch what they do. These people are in their house relaxing. There's nothing going on. There's no victim. There's just probation.
Morgan Hill Police Department probation search.
Probation search. So they're gonna talk to someone who's on probation.
They're in here. Yeah.
Morgan Hill Police.
Can I help you?
Yeah, Morgan Hill Police Department probation search. Open the door, please.
What good are they doing? What good are they doing?
Morgan Hill Police Department, open the door. Probation search. It's probation search. I think I hit a couple of people at the door. He's on compliance check.
Putting the gloves on so they can stick them into your body. Those gloves.
Okay, come out.
Those gloves are to stick into your body. That's what those gloves are for.
Because I don't want to hold time. Because you might be flushing and get rid of stuff. It's a compliance check. That's the whole point.
A compliance check. We're still complying to the state. You're at home. You're on probation. You need to show you're in compliance. You need to comply, whatever that means. It's a compliance check to make sure the probationee is in compliance with being free. They're not really free. You still are owned by the state.
Come on out.
Come on out. Come on out.
Okay, you can't get out. Shut the door. Okay. And step out. Yeah. Okay, come on out. Keep going. Probation search.
Probation search.
Come on out. Jason Luna.
He doesn't live
They
here
got-
anymore. He hasn't been here in 3 years.
This is the address he's listing.
So I am aware of that, but I was told that he did not live here for like more than 2 years. You guys weren't allowed to come inside the house.
You're wrong. You're wrong. Yeah.
And he's just gonna walk in her house.
Get out. Step out. Please step out. Step out. Step out, please. Step out.
Look what they're doing to this guy. Look at his arm.
What is going on? I'm not even doing anything. You are now. Oh my God.
Look at them torturing him. See the twisting of the hand and the wrist? Look what he's doing to his wrist. He's still twisting the wrist. Remember I put Tawny in cuffs? He's got those cuffs by the chain. So now they're out of the range for a while here. And they come through. But so if you guys want to know more, let's go down and take a look at what he said here, because I read this. It said always record the police. Let me pause that bad chicken. Let's zoom in and see what he says here. It says always record the police video. Almost a year later, no body cam footage, and still don't know who broke the glass in my home. I was taken to jail after being roughed up and given a 148 that was later dropped before my court date. My fiance and I do not have a criminal record, but still treated as though we committed a crime. In fact, I'm a former 2-time employee of the month at Centrella Recreational Center in, is that MH? What does MH stand for? Anyway, so it's very clear to me that the community deserves better than this from their police. So he did not have a warrant out for his arrest. They just came to his house and arrested him. Again, nobody at my home is on probation, but the video clearly shows that the people on probation and their families they live with are not getting treated fairly. So this was a family member of someone on probation, and they just arrested the people in the house. Nobody there was on probation. Probation is a privilege, so why does law enforcement treat these checks as shakedowns? I support police transparency. Without it, we're living in a filtered society. I've been scared to release the video in fear of retaliation, but I will not live in fear anymore. The community deserves to know what's going on in their city. Thanks to the medical professionals at DePaul Urgent Care in, what does MH stand for? That is not an what is that? Anybody know what MH stands for? Morgan Hill? Okay, Morgan Hill. In St. Luce's Hospital in Gilroy, the physician and therapist professionals, Golden Hill. Okay, so he needed help. So this is his channel, you guys. Maybe everybody make sure you get a screenshot or go over there and subscribe to Morgan Hill and say, hey, Chille showed your video. And listen, remember, he was not on probation. They came to his house and arrested him, and he was not on probation. If you go back and you listen to this video, listen to the beginning of it. When she comes out, listen, she explains, so the cop, he's getting his gloves on because he's a disgusting person. She's going to put gloves on, but listen to what she says right here in the beginning of the video. They came there all. You listen.
Come on out.
Jason Luna. He doesn't live here anymore. He hasn't been here in 3 years.
This is the address he's listing.
So
They're looking for Jason Lennon, and she says he doesn't live here anymore. We're looking for Jason.
Going back in, one going back in.
Okay.
Come on out.
Can you tell me who you're looking for?
Jason Luna.
He doesn't live here anymore. He hasn't been here in 3 years.
So the other guy in the background is screaming, he's not fucking here. You're at the wrong. That's what he said. Excuse me for my language. He says he's not fucking here. You can hear him scream in the background because the cops are beating on their door, and they don't know why the cops are there beating on the door. It's a probation search. They're looking for Jason Lennox.
Come on out.
Can you tell me who you're looking for?
Jason Luna.
He doesn't live here anymore. He hasn't been here in 3 years.
This is the address he's listing.
So I am aware of that, but I was told that he did not live here for like more than 2 years. You guys weren't allowed to come inside the house.
You're wrong, man. You're wrong.
Yeah, hey, don't touch it.
Out. Go.
He says, don't touch my chick. Step out. That's another woman. They just make her step out. She walks out all neat. But him, he was screaming at them. He's not on probation. He's done nothing wrong.
I'm not even doing anything.
He's done nothing wrong. He's at home.
Oh my God.
This man's at home.
Yeah, something.
He hasn't done a damn thing wrong.
I can't believe you put your hands on that. Believe it. Hey.
Going back in.
Okay.
Come on out.
Can you tell me who you're looking for?
Jason Luna.
He doesn't live here anymore. He hasn't been here in 3 years.
This is the address he's listing.
So I am aware of that, but I was told that he did not live here for like more than 2 years. You guys weren't allowed to come inside the house.
You're wrong, man. You're wrong.
Yeah,
Get out of here.
don't touch her.
So she says, I understand. You guys do me a favor. Everybody hit the like button. Hit the number 1 button. Everybody hit the like button real fast. Hit the number 1 button. It just shows we're still engaging, because I know a lot of people just end up staring at the screen and listening and stuff. But just hit the number 1 button. Everybody just hit the number 1 button for me, please. Okay, so I want, let's all subscribe to his channel, all right? Let's everybody go over there and subscribe to him. Can you imagine how alone he feels? He has shown that he wasn't even wanted. He wasn't even wanted. They didn't even want this guy. This guy right here, almost a year later, and no body cam footage. They go over and they break the glass in his house and they take him to jail after he gets roughed up. My fiance and I do not have a criminal record. And nobody follows him. No one's listening to him. Nobody's heard a single thing. In over a year, he can't get the body cam footage from Morgan Hill Police Department. Let's take a look. Let's take a look. Let's take a look at something just real quick. Let's take a copy of this video right here. I'm going to copy this, and now I'm going to go here, and I'm going to go to my Facebook page, and I'm going to go to Morgan Hill Police Department. There it is. It pops right up. Okay. Morgan Hill Police Department. There it is right there. Can you believe that? Now, how would it be? Now, of course you're hiring. You know why? You need people who are willing to hurt other people and abuse and not follow the Constitution is what you need. That's what you need. So let's see what we got. Oh, you got a picture of the dog, but not the breaking into that guy's house and arresting him. So I think on these cute little dogs right here, I think I'm gonna take the video, that gentleman part right there, and I'm gonna paste it right there. I'm gonna paste the link, and then I'm gonna say, holy cow. Release the body cam footage. That's what I'm going to do. I'm not telling anybody else what to do, but that's what I'm going to do. I went right over to the Morgan Hill Police Department. They got a phone number right here. They got a phone number right there. There's their phone number. It's Friday night tonight. What if on Monday morning we all called the Morgan Hill Police Department? What if we gave the Morgan Hill Police Department a phone call? What if we did that? What if we did that? What if we all called the Morgan Hill Police Department? What if I put that in the notes? What if I put that in the notes, huh? What if I put this phone number right here on the title? On Monday, we all call the Morgan Hill Police Department and say, we just watched a guy. I wonder, is this guy's name on here? Is his contact information on here? So this says Morgan Hill PD Officer versus Community Safety, and it's called Morgan Hill SPB. I don't know what that means exactly. Yeah, see, I'm the only one who's commented on here. I watched this already, just so you guys know. And so I'm just like, okay, so now let's go to, let's just take a look at his channel, Morgan Hill, 6 subscribers, videos, 13 subscribers. So, right on, 7 people joined his channel. Thanks, guys. That's amazing. That's amazing. Does he have an about? Does he have a contact? Civil rights and civil rights citizens. Social freedom and equality, view email address. Okay, let's see what his email address is so I can email him and talk to him about getting his story. Oh, there it, Morgan Hill SPB at Gmail. Okay, copy email address. Now let's go over here to Gmail. Gmail. And let's send him a real quick email, but I don't think this email address is working. Okay, so let's go. Let's paste his email address right here. Subject line, RE, we hear you. We are coming to help. Amigo, reach out. Let's do a Zoom interview. You should get some subs. You should meet some of my friends. That's you guys. That's you guys right there. So I'm sending that to him, Morgan Hill SPB. Make sure you guys subscribe to his channel, and we're gonna let him know. There it is. He's going to meet a few of my friends right there. There it is. Right. Because look, you know, it's just, it is just absolutely mind-blowing to me that we're living in this absolute, obvious, and obliviously, horrifically bad tyranny of government, that they have taken the power. You know, I've been giving you guys Supreme Court cases, so I'm figuring that the 150 people that come and hang out with me on Friday night, I think that you guys have probably looked at Tenney versus Brandoff from 1951. You looked at Chaplinsky versus New Hampshire, 1943, 1942, 1943. If you haven't taken a look at Chaplinsky, Chaplinsky versus New Hampshire, I believe that's 40, I believe it's 1942 or 1943. I'm going to say 42. You should know that case that talks about fighting words. So they've taken the power of our speech and said that if you say these words, then they're fighting words. And they did that in Chaplinsky. So now you don't have the right to free speech. 1919 cynic, they're going to take away your speech. The Second Amendment is going to be stripped away by the 1911 Sullivan Act, and then the 1934 National Firearms Act, and then the 1939 Miller versus United States. So we are living in this time period where 1951, Tenney versus Brandoff, they take all of the power for themselves and say, you guys, we are immune from prosecution. We are completely immune from prosecution. And so when you start to look at it, and then in 68, they say you don't have a Fourth Amendment right to be secure in your person, because absolutely anybody, any cop can just run up and grab you, and that is not a violation of your Fourth Amendment right. We're living in the absolute dystopia of society. We're watching it. We're watching it. People are so lost in what they're doing that they're not paying attention, that we're losing all of our rights. And you just saw, here's how far it's gone. His name is Amir Locke. You can be asleep on your couch with your computer screen open, and the cops can just come in and just kill you. They can just come in and kill you. The cops can just come right into your house as you sleep and kill you. That can happen. You know, what the reason why I talk about hobby and theory, and that man is this brutish beast and we only care about our own self-interest, I'll be 100% honest. I don't want that to happen to me. I think about my own skin. I think about my own self. I don't want the cops to be able to get a key from my landlord or whoever, and then they just come into my house and they just kill me right there. So if Thomas Hobbes is correct, I don't want to be killed. I don't want to be murdered. I don't want to be murdered. It's why I don't take the global medication. I am, whether I like it or not, a super athlete. I have been since I was a kid. Always have been. And so what I saw from some super athletes is they were so adversely affected by the global medication. I don't want that to happen to me. I love being physical. I love, right? So now we have this huge distrust. And so I don't trust the people who are supposed to uphold the social contract for me to be selfish about. Does that make sense? I don't trust the people who create the... We're witnessing it. We're witnessing it. We have to fight for our rights or we're not going to have any. We have to fight for our rights or we're not going to have any rights. What are you going to do? You can't. You don't understand. They target us. They target us. They target us in a uniform, organized way. And just remember, that could have happened to that person with a wrong address. It could have been a wrong address. It could have been anything. It could have been absolutely anything. It could be a wrong address. It doesn't even have to be your name on the warrant. It can be just they put the wrong address in there. You die. Sorry. Sorry, the city's going to pay your family $10 million. What happened to you? You're dead. You're dead. The city's going to pay your family $10 million, though. You're dead. And so I go back to Hobbes. I'm doing it for me. I'm doing it for me. I don't want that to happen to me. I'm selfish. Gosh, I'm selfish. The idea that that could happen to me motivates me to do something about it. Motivates me to do something about it. When are we going to stop raiding people's houses? It's not working. Raiding people's houses hasn't made it any better. Go across the board of criminality. Raiding people's houses hasn't made things any better. Raiding someone's house hasn't made the world a safer, better place. It's made us not like the police and fear the police. And by the way, you guys, just so you know, for all you people who think I'm a little bit harsh or a little bit hardcore, just get no-knock raided one time. Just get the no-knock. I got it twice, but just get the no-knock raid once or twice. And then maybe you, I mean, I'm not saying that this group of people is like that, but anybody who comes across my videos, oh, he's so intense, he's so hardcore, just get no-knock raided a couple times. That's all. Go through guns at your head, people scream, I'm gonna fucking kill you! I'm gonna kill you! I'm naked both times. Both times. First time I was in a tub, completely buck naked. Second time I was in bed, I sleep naked, I was naked. All right. I was going to cut together that Graham versus Connor, but I'm just going to leave this. I'm going to break this. I'm going to cut that little piece out and put it up and let people watch it. That's what I'll do. So, all right, guys, anything good from you? Anything good? Anything good? Anything good? Hey, thanks for the super chat. I didn't see any. I appreciate the super chat. Thanks a lot. I appreciate it. Did you guys, anybody pick up a poster or an ebook? If you guys can pick up a poster or ebook and you want to learn about my business and about what I do, that's what I do. I sell that poster and ebook on DeleteLawZ.com with a Z, DeleteLawZ.com with a Z. Please consider picking up my digital poster, ebook, or hard copy poster. If you would, please consider picking that up. I appreciate it. That's what I do for a living. And yeah, I love talking to you guys. Thanks a lot. I appreciate all your support. God bless you. God bless your family. I wish you guys nothing but the best. You know, as you know, I will be back tomorrow. I've got a real treat coming for you guys. You'll see the police reform thing that I created is pretty incredible. A whole new way to police. I'll unveil it soon. Anyway, I'll let you guys get out of here. Thank you guys so much. Hit your like button if you would before you go. Hit the number one. Hit the number one, and I'll get out of here too. I mean, I'll get out of here too. All right. Thanks. Nice talking to you guys. His name was Amir Locke. His name was Amir Locke. Rest in peace, Amir. And we see you, brother. We see you over there in Morgan Hill. Anybody remember, go by Morgan Hill Police Department Facebook page. Everybody take the link to that guy's video and go show that to Morgan Hill Police Department. Take the link from the YouTube video and go show that to the Morgan Hill Police. Put it right on their page. Rest in peace, Amir. God bless you, sir. I hope you're on a better journey. All right. Later, guys.